Our next panel is on digital assets and cryptocurrency. Really a topic that seems to change every day. And honestly, a lot of the reason it's changing every day is because of the people you're going to see on this panel who have been all over the news for different cases and in different capacities. But this is a great panel. Let me start with David Hirsch. David's in the middle there. He's the current chief of the crypto assets and cyber unit at the SEC's Division of Enforcement. Prior to that, David served as counsel to SEC Commissioner Caroline Crenshaw. Welcome, David. Thanks for joining us. Kristina Littman to his left, a partner in the litigation department at Willkie and co-head of its digital works practice. As many of you know, Christy was David's predecessor as chief of the crypto assets and cyber unit in the enforcement division. She also served as senior advisor to then SEC Chairman Jay Clayton on enforcement matters. To my immediate left is Dr. Nicole Moran. She's vice president at Cornerstone Research in DC and a former research economist at the CFTC. Also very pleased to be joined by Steve Peikin. Steve is right next to Nicole. He's a partner at Sullivan Cromwell in New York. But of course, from 2017 to 2020, Steve served as co-director of the SEC's Division of Enforcement and also as a former AUSA in the Southern District of New York, where he was the chief of the Securities and Commodities Fraud Task Force. At the far end of the stage is Christian Schultz, a partner at Arnold & Porter in Washington, D.C., and former Assistant Chief Litigation Counsel at the SEC. And the moderator today is Matt Solomon. Matt is a partner at Cleary Gottlieb in DC. Matt is right here, by the way. He's going to be joining me at the podium. But he was also previously a white-collar prosecutor and unit chief with the DOJ and the SEC's Chief Litigation Counsel. Matt, let me turn it over to you.
Okay, a lot to talk about, not a lot of time. We're going to try to end a little bit before 12:30 because we've got to transition before the chair begins to speak. Why don't we dive right into it? And Dave, let's start with you. You took on your role as chief of the crypto asset and cyber unit almost exactly 1 year ago. Give us a sense of the goals that you set for yourself and set for the unit a year ago, and then give us some sense of how and whether you think those goals have been accomplished and what's left to do.
Very much, and before I get started, I should note that while I'm here in my official capacity, the views I share are my own and do not necessarily reflect those of the commission, the commissioners, or fellow staff. So a year ago, when I was taking on this role, and I was actually had the opportunity to come and speak at this event, thank you, Bruce, I was thinking a lot about where investors are facing risks in these markets and where there are issues regarding market integrity. And we talked on that day about, this event last year, about market intermediaries. So folks who are affecting or facilitating transactions in crypto asset securities. And the need for them to register if the law so requires, unless they qualify for an exemption. Also was thinking a lot about investor harm, both from fraud and from just inadequate disclosures from those who are making offers and sales of crypto asset securities to retail investors particularly. So in the last year, we've been extremely busy. I'm fortunate to lead a exceptional team of staff attorneys. I'm joined by a Deputy Chief, Jorge Tenrero, who is excellent, and together we have been very busy. We've pursued a number of settled and litigated matters against crypto asset security intermediaries for failing to register, as we alleged, in violation of securities laws, as brokers, as exchanges, as clearing agencies, often alleging all of those violations against a single entity in a single complaint. We've also been very active looking at market manipulation and fraud and unregistered offers and sales, regardless of the label being placed on the particular offering by those who are promoting it. So regardless of whether they described it as an NFT or as staking as a service or some other product, we look to the economic realities to determine whether we think that the offer and sale should have been registered and there was a violation by failing to do so.
And just to picking up on the market manipulation point, I've heard you talk about the potential opacity of certain digital asset exchanges. This is what you are saying publicly. Are there cases that we should be aware of that may not be headline matters like the one Steve, for example, is working on, the Coinbase case, that touch on some of these issues involving potential market manipulation or some other priorities that may not be as front and center in the press?
I appreciate the question, and yes, there are. So in September of 2022, the Commission brought a enforcement action against Hydrogen Technology Corporation, as well as Moonwalkers, a market maker in the crypto asset securities space. And in that matter, we alleged that the market maker, in support of the seller, the promoter of a particular token, was engaged in what looks a lot like classic traditional market manipulation. They were making spoof orders, they were using bots, they were executing wash trades. And although I think a lot of retail investors in the crypto space think that they have a degree of advantage over traditional markets because many transactions are recorded on a blockchain which is publicly viewable, a lot of the transactions are never recorded on the blockchain. They are internalized within either centralized exchanges, or they might be recorded on the blockchain, but because of the pseudonymous nature of who controls wallets, it is difficult or impossible to discern that the same actors are just trading back and forth either between wallets or between accounts held at centralized exchanges. And simply reviewing blockchain records is not adequate to inform you as to whether or not you're dealing with a legitimate, robust organic market versus just the appearance of one created to try and extract liquidity from retail investors.
Thanks, Dave. Kristy, you were Dave's predecessor. You've now been in private practice maybe going on a year, if I've got that right. Tell us about your experience now flipping the script and representing a lot of the same entities and individuals that you had your sights set on from an enforcement perspective at the SEC, and give us some insights about what you've learned about the industry and just generally any insights that you've gleaned from being in private practice.
Well, I'll say the one of the most surprising things is how much everyone clamors for insight around kind of every little thing that comes out of the division. And every little thing that comes out of, even just a speech or a filing in a litigated matter, people in the industry are so hungry for additional insights and additional understanding about the way that the law is kind of developing in this space that everything gets really, really dissected. Every line of every order of every speech is, it really is, it's in the spotlight, and people are trying to understand how they can interpret that and what risks everything presents for them. The other thing that I think is a little difficult to observe when you're at the government is that the players that Dave described are obviously really important, and you have to worry a lot from an enforcement perspective about manipulation and fraud. But there is also just this huge body of intermediaries and kind of institutions transacting in digital assets who have a background in traditional finance and kind of are used to traditional finance compliance functions and are trying to build compliance functions at their own institutions that would meet government muster, right? There's a lack of infrastructure around things like trade reporting, and so you can't really build the same systems in crypto trading platforms that you would see at a traditional exchange. But there is an effort, in my view, by a lot of these intermediaries to have robust compliance functions and to kind of take the perspective of, let's assume that the SEC is going to think everything we're doing is touching on a securities transaction. So let's build a compliance regime that does try to prevent trading on material non-public information, or tries to, obviously they have very strong BSA and AML programs, because there really is an effort, even though I think there's maybe a little bit of a vacuum in terms of regulation targeting that kind of infrastructure. There's a real desire by these credible large institutions to build compliant models that aren't going to be particularly susceptible to a lot of the abuse that Dave was just describing.
Got it. Let me pivot a little bit to some of the legal developments going on in courtrooms around the country. Obviously, there's no legislation that's been passed or likely to be passed, at least anytime soon. There's been no rulemaking. Christian, there's been a number of litigations going on. You used to litigate cases for the SEC. You're now defending folks in some of those cases. we've got, Kick and Telegram, we've got Libri, we've got, FTX going on right now. Maybe that's a different animal, more of a fraud case than a crypto case in my judgment anyway. We got Ripple, we got a summary judgment decision there and some other actions in that case. And of course, Coinbase, which we're going to talk about with Steve in a moment. But give us a sense of how much the law has really moved in the last year or so. I remember sitting where you're sitting a year ago and saying, hey, it's great, we got all these cases, we're going to start to get some clarity, this is healthy. And I think we have gotten some judicial decisions, but it seems like there's a lot more to go before we really have clarity. I don't think anything's hit the appellate level, for example. Just give us your take on where things stand right now in the courts.
Well, we are getting more clarity. We've gotten Judge Torres's decision in Ripple and then her decision on interlocutory appeal, which we may talk about more later. It might have been a strategic and tactical error by the SEC to go that route. And then we've got the Terraform Labs decision, which the SEC tried to rely on. I think the takeaway I see from a lot of these cases, and I think Terraform Labs is a motion to dismiss case, whereas Judge Torres' decision in Ripple was at summary judgment with a fully developed record. She really laid out that courts, as I think we've seen in other cases, are taking a facts and circumstances approach to reviewing the initial sale and offering of digital assets, and then how those are being dealt with in the secondary market, and how does that play into the Howey analysis. So I think we're getting more clarity, but I think there's still ground to be laid, particularly if, for example, Ripple makes it to the Second Circuit.
And Steve, let me get your thoughts on this too. And a couple questions. You're obviously front and center with the Coinbase matter. You filed a reply yesterday. As we look around at what judges are doing in different courtrooms, we see, for example, in the preliminary injunction that the commission brought against Binance, for example, you see Judge Jackson, for those of you who have read the transcript, expressing some discomfort and having to deal with these very complex issues as an Article III judge, not a specialist, a generalist. Give us a sense, Coinbase, or maybe speak generally if you can't speak specifically about that case, how have you worked to distill complex concepts for generalist judges to make things digestible, to put your client in the best position to get its arguments put forth as effectively as possible? And then give us your own sense about where the law is right now. You were at the commission a couple of years ago. These litigations were launched. We're further along now. I think we're all trying to read the tea leaves. So give us your sense about where things are right now.
Yeah, so thanks. I think there's a wide variety in the sort of sophistication and expertise of various audiences, be they regulators or judges. And we've seen, some regulators and enforcement authorities with high degree of sophistication, and you can talk to them at any level of complexity. And then some where they're, quite novices, and you obviously just have to adjust the level of detail of a presentation for the audience. And I think we've seen, at least in the judicial decisions that have come out recently from Judge Torres, Judge Rakoff, and Judge Fela in a civil dispute, I think a high degree of sophistication from the bench. So I don't get the sense that any of these judges are overwhelmed by the fact that we're debating on a landscape involving new technology. I think just picking up on what David said, when I was at the commission, really we focused on primary offerings. The ICO cases, which developed over time, culminating, and I think in the most important of those cases were the Telegram case and the Kick case, which were Chris C. supervised. At that point, I viewed those cases as presenting programmatic risk for the agency. It was really important for the commission to win those cases. It was going to continue. Now the commission has, I think, branched out, as David mentioned, into sort of focusing on intermediaries, be they lenders or platforms or exchanges. And I think from a policy perspective, it makes sense because there's so many offerings and so many tokens that it's a bit of whack-a-mole. And if the commission really wants to assert its authority broadly, this is probably the most efficient way for it to do it. But I think that what is teed up is a pretty significant and unsettled legal issue, which is, are secondary market transactions in digital assets that maybe at the primary offering stage met the definition of investment contracts, when traded on a secondary market, do they continue to be investment contract securities? And I think that's a complicated and question. The commission has taken the view in the Coinbase litigation that if you buy a token and expect it to hope it goes up in value based on statements that the promoter is making, that's an investment contract. And Coinbase takes the view that reads the word contract out of the definition of investment contract. There has to be, the token purchaser has to have some right or entitlement to something, some profits or proceeds of the promoter. There has to be some kind of arrangement between the promoter and the token holder. And that issue is now issues joined on that and will be decided. And I think, depending on how that comes, that's going to be significant for this initiative.
Yeah, and Dave, I'd be remiss if I didn't give you a chance to comment. I know you can't comment on current litigation, but just on the investment contract and the way that district court judges have begun to put some flesh on the bones there. Is there any comment you can make about where the commission sees things right now in the courts and what you expect in terms of major decisions coming up that may, again, continue to add some additional authority that you may be able to use programmatically?
I'm, as you acknowledge, very constrained in what I can talk about in the context of ongoing litigation, beyond the fact that we have exemplary litigators working extremely hard to present the commission's positions on these matters.
So do we.
Not shocked to hear that perspective either. But I think the litigators we have at the SEC will do a better and more nuanced job of presenting the position of the commission than I'd be able to do in this setting here, so I will leave it to them.
Do you have the resources to continue to bring these kinds of cases with the likes of Steve Peikin on the other side going forward? Do you feel like you have fortified the litigation function and not with subject matter expertise and with additional resources to be able to take on more and more cases? Because it does seem like both individuals and entities are more willing to put the commission to its proof. Obviously, you're still getting a number of settlements, but there seem to be a lot of active litigations out there, at least when I compare it to several years ago.
No, we are extremely active in litigation right now. We have additional resources, and we're going to continue to monitor the markets, and where the commission authorizes us and there's been a recommendation made, I anticipate that appropriately it won't be a resource issue if we decide that there's actions that need to be brought.
Okay, we're going to come back to all these issues,
Matt,
but let me,
I
go
was
ahead.
just going to add on Steve's point about the judges are very sophisticated, and the SEC has a good team, but they're not just going up against Steve and you in Ripple, but they're also dealing with a raft of amici briefs that are pretty robust, and some have been significant, while maybe not cited in, say, Judge Torres's decision. There were some very compelling amici briefs put forth there. Steve's filing yesterday talked about a couple of the amici briefs in the Coinbase case that are compelling, and I think makes it a little more of a challenge for the commission staff.
I don't think these issues are going to rise and fall on commission resources. The commission is not going to be outgunned and outmatched. They're not going to, if they don't prevail, it's not because they don't have the resources to match what industry wants.
Yeah. Nicole, let's bring you into this. There are complexities to these cases, and when a case gets beyond a motion to dismiss stage, goes into discovery, a summary judgment, potentially trial, experts necessarily have to get involved. There's a lot of novel questions these cases raise. For example, where do trades take place? If they take place on a platform that's overseas, are those extraterritorial trades not within the ambit of the SEC's subject matter jurisdiction? These are questions that are often questions of first impression, among other issues ripe for experts in digital asset cases. You have worked on a number of these cases. Give us your perspective on the challenges in terms of finding suitable experts in this space and the kind of experts that have made sense in your practice and that may make sense going forward.
Yeah, thank you. So finding testifying experts is sort of an art, not a science. And just like everybody now is an artificial intelligence expert. For a while, everyone was a fintech or a crypto expert. So I've probably talked to 75 experts, over the last couple of years, where you just have to screen through and see who just put fintech or crypto on their CVs and who, in fact, is an actual expert in the area. And so it really depends on the needs of the case. We need a generalist who can do damages and has done it 20 times, right? And can just alter how they do damages. Or do I need someone to fly to a different country, look at source code, and figure out how that particular program or exchange or protocol is actually run? So these are very different types of experts. So depending on the case and the level of detail that the expert needs to already have mastered or will master is really what we look for in cases.
Hey, Mag, can I ask a question of Dave? So I think a year and a half ago, we saw in the budget that the Commission expanded the crypto and cyber unit and was planning to staff up. On the point of experts, what are you all doing to bring in people who have real expertise in the crypto space to be part of that team?
I think Christy made a lot of progress in this regard. We have continued, since I've taken over, to ensure that we have not just technically skilled staff attorneys and accountants, but also technical experts who can assist with tracing, with analysis of code, with big data sets, and with developing their own queries. And so I think we are recognizing that in this area, challenges are both legal and technical, and that we make sure that we have the team we need to be able to surmount those challenges. And also, when we're in litigation, we rely on outside experts as well.
I want to get back to my favorite topic, litigation, because it really is front and center when it comes to crypto. That's how the law is being made right now. And Christy, I'll come back to you. In terms of preliminary injunctive relief, TROs, when you were at the commission, you brought a preliminary injunction against Telegram, for example, but not Kik. The current commission brought a preliminary injunctive action against Binance. Other litigations have been ordinary course. Can you help us understand? I think we can appreciate the commission's view of potential harm to investors, but help us understand the thinking that goes on in the building about when to go in for that kind of immediate relief and being under pressure to make that prima facie showing again in front of a judge. And I think we saw this play out in the Binance case in front of Judge Jackson, very sophisticated, very intelligent judge, but struggled, I think, with PI papers to sort of make sense about exactly what she was supposed to do. That ended up getting to a negotiated solution. But give us some insights about that, because obviously clients are always wondering how and whether the SEC is going to use that type of very extreme action.
Sure. I'll share my insights kind of with respect to how I thought about it when I was running the unit. I do think there's probably a little bit of a shift that is perhaps the result of kind of public pressure and the need to take certain actions. With respect to Telegram, that was an instance where they had not yet issued the grams. And so because they'd kind of conducted the sale, but they hadn't yet issued the tokens, there was an opportunity to prevent the tokens from entering the open market and kind of reaching retail investors. And so we were able to go in and move for the preliminary injunction. And actually we did negotiate kind of a longer TRO there so that they would delay the issue of the grams so that we could kind of have an expedited preliminary injunction hearing that ended up looking more like a summary judgment ruling, because we did like an expedited discovery period to get to that point. But it was really a function of knowing that there was a specific potential investor harm that we could stop and that hadn't already begun. Other cases where we had ongoing violations, Ripple, BlockFi, cases where the conduct had been going on for a long period of time and was ongoing, we didn't opt to kind of take those emergency measures because in my view, you don't want to go into court for the first time in front of a federal judge with the position that was kind of what I would call a staff-created emergency, right? I mean, it's a little hard, I think, to go in and say this is an emergency when you've had this conduct outstanding for years and you haven't yet filed. So I think, I'm not sure that there are certainly cases, present-day cases like Binance, that don't necessarily fit that mold.
And it's fair to say, I guess, if a defendant can withstand that initial complaint and gets to quick discovery, that's obviously quite a resource strain for the commission to have to do expedited discovery at that point in time. Is that fair?
Absolutely. Okay. It was a huge resource commitment. But in that, particularly in Telegram, I think it was worth it because obviously we prevailed. Yeah. But it was also, there was a specific goal, which was to stop retail investors from buying grams.
Okay. So Steve, the SEC is not the only kid on the block here. Obviously, DOJ is out there as well, and state securities regulators, AGs, and others. Give us a sense of what the other risks are out there for participants in this space, what you've seen, and how you sort of make sense of the alphabet soup of regulators. And I think we just saw the New York AG pop up about a week ago and bring an action, for example.
Yeah, well, I think in the fraud space and manipulation space, there's obviously DOJ. CFTC is obviously on the scene as well, and I expect they will become more active, in the next, period. The states have been I think somewhat to my surprise, been very active in the space. There have been two matters. We worked on the BlockFi settlement where we settled not only with the SEC, but with 53 states. I thought there were only 50, but apparently there are 53. And they were very well coordinated. They had a leadership group and they had template sort of resolutions, which ended up getting picked up by all the states. And, if you wanted to resolve things, it was pretty constructive process. It's been more fragmented in Coinbase, where 10 states filed cases on the same day as the commission filed in Coinbase, and about half of them sought sort of immediate cease and desist relief, and half of them didn't. So, and there seems to be less coordination there. I think historically the New York AG has been more of a lone wolf and less coordinated. But I think there's no one template. I think it really varies from case to case.
Let me say, Matt, I think the New York AG surprised not just the defendants, but the SEC and the DOJ. I don't think that was anything anticipated that quickly. I don't know if Dave has any perspective on that.
Yeah, I mean, Dave, what about that? I'm hoping to get something other than platitudes, and I'm not no offense by that remark, but this issue of coordination.
Stick with the platitudes, Dave.
Yeah. This issue of
Steve and I can represent you for a moment. You don't have to take this bait.
Yeah, I'm gonna give it a shot. This issue of collaboration or lack thereof between the states, the SEC, the CFTC, DOJ. I understand everybody's talking in theory, but when you look at it from our perspective, it really does seem like, at times anyway, there might be some left-hand, right-hand issue going on, some jockeying for jurisdictional terrain. I mean, that's the strong perception. Just take one example, the CFTC came out and sued Binance, right? I'd love to ask you, did you guys know they were going to do that? If you knew, how much notice did you have? I know you can't answer that, but give us an understanding as best you can. Are these agencies talking with one another? Is there that collaboration? What more do you think could be done to enhance that collaboration? Because I'm sure there's always things that could be done to have a more coordinated government apparatus.
No, it's a totally fair question. So not commenting on Binance timing or any other specifics, but just macro out to the relationship level, we have excellent relationships with our law enforcement partners, whether that's criminal law enforcement at the federal level or civil law enforcement at the federal level, and sometimes criminal and civil at the state level. We work well with all of those partners. We share information pursuant to properly granted access requests. We coordinate and work in parallel where appropriate. There will be times where we are going to not bring the same matter even though we may have all looked at the same matter, there might be times where for resource reasons, efficiency, or just the centrality to one specific regulator's mandate or jurisdiction, it makes sense for only one regulator or actor to move forward. There are times where all of our interests are at play, and it's important from a messaging perspective as well as a remedies perspective that all of us be present. And timing, I think we try and coordinate as much as possible, but there are going to be times where one agency feels the need to move forward more quickly, and I think these are long relationships that have been built over time and that will be maintained over time. And so we do our best to work together where that's appropriate and deviate only where that's necessary.
And going back to BlockFi, Steve, that I think you had experience with, I mean, what's your experience been? Is there something you can say, having served in government, obviously, criminal, civil, worked with other agencies, what are you seeing out there, maybe with a slightly more expert eye than most people about coordination or lack thereof? And how do you counsel clients when you have multiple actors who may have overlapping jurisdiction?
Yeah, look, I think it really depends on what the client's objectives are. And, in many, cases, outside the crypto space, in the crypto space, where you have a highly regulated entity that's looking to resolve things, with the government, it's really the onus becomes on you to try to herd the cats together, to try to bring things to a unified resolution. And I think that, in general, I think the government is receptive to that. If you're in a settlement kind of posture, it takes work, and you sort of, want to prevent the free riders and the latecomers, et cetera. But, you have to be proactive. And sometimes, in various matters where, we've had, maybe an agency pop up in the middle but then go dark, we'll reach out to them, say, we haven't heard from you, but we're headed towards a resolution. If you have something you want, speak up.
Yeah.
And that strategy, I think it's not perfect. You don't control it, but really you have to work hard to try to bring people together.
I think the practical reality is clients don't want the regulators coming out piecemeal, right? You'd rather have a sense, especially if you're settling the full universe of what you're going to have to settle to, but you also don't want it dragging on over time, right? You want to be able to consolidate it into one event.
Let's pivot again to actually having to litigate these cases and putting on proof as a defendant, and back to economic analysis. I think you have a PhD in economics. It's impressive. And by the way, you're a partner, not a VP. I should make that clarification from your intro. Nicole, tell us about some of the economic issues that come up, whether they're in investigations or actual litigation, where shops like yours can help us as defense lawyers prepare, whether it be the Howey factors on reasonable expectation of profits, if you ever get there, disgorgement, for example. I mean, there's a bunch of things that come to mind, and these are going to be integral parts about litigating these cases, not just litigating them, but defending them at the enforcement stage to try to show the regulators that there's significant enforcement risk, not just in relation to the substance, but perhaps in relation to remedies. Can you just give us a sense of how those issues percolate in these cases?
Yeah, so in many cases, it's not just one expert or one issue. A lot of times it's 3 or 4, depending over the course of the case. For example, market microstructure experts end up being very important, and they really focus on how the structure of the market works and can ask the right questions. They're formally trained PhD economists, the testifiers, and know what questions to ask and know what is the differences between crypto and some of the more traditional markets. For example, market efficiency. Sometimes we take that for granted in securities markets. Of course they're efficient, right? But they're not always in cryptocurrency, especially for tokens that are not traded very much. So it becomes really important to know the traditional tools that are used, but also how that differs in the crypto markets, for example.
Got it. And another issue, I mean, Howey is obviously front and center in these cases naturally. This major questions doctrine has also has some primacy now, and I saw in your brief that you filed yesterday, Steve, that's a significant part of even your reply is devoted to the major questions doctrine. Could you just give us a general understanding? What is it? Why do you think it matters in the context of crypto? And anything else you think folks should know? Because again, that's an argument that seems to be gaining traction, at least among the defense bar. We'll see what judges end up doing with it.
Yeah, so the major questions doctrine, it's separation of powers principle and a principle of statutory interpretation. And it basically says that courts should not presume that agencies are delegated responsibility, executive agencies are delegated responsibility over substantial portions of the economy or important political questions, absent some specific congressional directive. And, so in the context of crypto, industry has taken the view that because of the lack of clarity, disputed jurisdiction, pending legislation, and the importance of crypto to the national economy, that this is a major question that has not been delegated to the SEC to, basically oversee. The SEC in litigation obviously takes a different view. They say, we're just applying, a definition that's been in the 33 and 34 Acts of an investment contract for, a long time. And we're just applying it to a new technology as we have over, the life of these statutes. And the crypto economy is not so significant in comparison to things that the major questions doctrine has applied to. So, we have authority, right? The one decision on this that I'm familiar with is Judge Rakoff's decision in the Terraform case, and he really gave the issue the back of the hand, was very, very dismissive of the defense's argument. It's teed up in the Coinbase case again, and one interesting thing, the SEC has taken the position, not only the things that I tried to summarize, but also said that the major questions doctrine only applies to regulation, not to enforcement, which, I frankly have difficulty, I don't really understand that argument, but, we'll see. This is teed up for, again, issues joined for decision on this.
Got it. Thanks.
I'll add, I'm sensing, particularly in the Coinbase matter, kind of a shifting of maybe a little more open-mindedness for judges to some of these affirmative defenses. I think in Kik and Telegram and even in Terra, they were given kind of the back of the hand, the idea of like the void for vagueness argument in Kik. They just didn't get a lot of real estate in any of the opinions. But as I think the SEC's reach expands beyond kind of those just standard token issuances, I think we're seeing judges scrutinize those affirmative defenses like the fair notice defense a little more.
Yeah, look, the other thing that has to overlay this is, at least in some corners of the judiciary, a real hostility toward the administrative state, right? We had the displeasure of living through, Lucia and Lou, et cetera. And, I think, there are some courts that are mistrustful of agency action. And, there's a trend, to try to challenge and retract the administrative state. I think a lot of people that watched the CFPB funding case in the Supreme Court, probably were disappointed because the judges were quite dismissive, at least that argument. So we'll see how this plays out over time.
I think it's a major issue, and I think that we see as administrative proceedings become impractical or impossible to use, even in a 102E type case. We heard from a prior panel, the commission is having to bring cases in federal court. I mean, Dave, that is a resource constraint in the sense that all of these cases, not just crypto, but some of the more technical, trading type cases that would have been relegated to an AP because there were sophisticated fact finders, administrative law judges, these are now being brought in federal court. Have you seen any impact to your program from the fact that there really are no more litigated APs, and therefore you've got your dedicated litigators, but there's a lot of other litigators working who might be working on crypto cases, but they may be bogged down in federal court litigation on negligence type cases, on cases involving strict liability claims because of the inability to choose a different forum?
That hasn't been my experience. My experience has been when we need a group of litigators to go to court because the commission has authorized us to pursue a particular enforcement action, that those people have been ready to answer the call.
Yeah, okay. Let's do this. I'm going to have a little bit of a speed around here because we're going to try to wind up a little bit early. There's a lot of people listening who may be more junior lawyers, maybe associates at law firms working in-house, and then some people who may be a little further along in their career but who are fascinated by crypto and all the interesting issues around it. I'll start with you, Christian. Just give us a sense of how you got involved in crypto and how you've sort of learned what you need to know in order to be able to competently defend a crypto case. Then we'll just go right down the line. And anything you think would be useful for younger lawyers to know, I think would be great.
Sure. I had a little exposure when I was at the commission, but I didn't get to work as closely with Kristy and her team. So it was a lot of doing research and reading the cases, reading the opinions, digging into the technology, getting to know people in this space who can provide some technical advice to help me understand how the technology works, and then reading briefs like Steve submitted yesterday that really help clarify the issues and put something before the court to resolve.
And then Kristy, you and I were doing insider trading cases together at the commission. I know you didn't know much about crypto, and I sure didn't at that time, but you obviously put yourself in a leadership position at the division, brought a lot of important cases. You're now doing this kind of work on the defense side. Just give us a sense of how you got there and how you built your knowledge up, and now how you feel like you can operate in this space seamlessly as a defense lawyer.
I mean, it's kind of, I think, like most people here, on-the-job training. I was in Chairman Clayton's office at the time when the SEC was really starting to scrutinize these assets, and Steve was the director of enforcement. So I think his probably intro to this is similar to mine, and I won't kind of reveal some of the questions Steve asked me over the years to gain an understanding of the technology. But it was on-the-job training. We had to figure out the technology, figure out how and whether the securities laws applied to it. And the nice thing about crypto is, as Nicole alluded to earlier, like a lot of people will say they're crypto experts, but it's a relatively new field in the grand scheme of securities enforcement. And so it's constantly evolving. There's kind of always an opportunity to be at the front edge of that and to continue to learn and understand the evolution, because it really is kind of taking place present day.
What about you, Dave?
So it started when I joined the commission in 2015. My soon-to-be manager, I asked what I could do to hit the ground running, and she said, well, I think I had been a private investigator just before joining, and she said, I thought the skills would probably transfer, but if I was interested, they had some Bitcoin cases. Like, oh yeah, no, very interested in Bitcoin, and it went to Google, what is Bitcoin?
That was the question Steve asked.
When did he ask that?
It's a totally fair question.
Don't tell us.
And then just, countless hours of podcasts and what was then crypto Twitter, now I guess crypto X, trying to both understand the technology, but also the culture, because I think both are primary drivers in the markets that we are observing.
What about you, Steve? And Steve, you've done spoofing, you've done a lot of complex areas like trading type cases. How did you get involved in this kind of work? Obviously, you had to as the director, and then maybe I can put a gloss on you. What's different, or what's the same about this kind of work as compared to other kinds of work?
I joined the commission in June of 2017, about a month before the Dow 21A report was released. And there was a fairly advanced draft of that when I got there. And that was the first time I'd ever heard the term initial coin offering. So I really started from zero, as I think Kristy has made clear. I don't really consider myself to be a crypto expert in terms of, being the best at understanding technology. But I think, first of all, two things. One, on the defense side, we don't really get to choose what we work on. We kind of work on what they choose for us to work on, right? We follow what the enforcement priorities are. And there's been such an emphasis on crypto that we really, had, no choice but to be involved in the stuff. And it really does, for me, map on to a lot of traditional finance stuff. And, I've spent most of my career working on securities and commodities, trading related matters, and the parallels and the overlap are, really substantial. So, I think it's just mapping a new technology and new products onto kind of an existing regime.
Is it different? One follow-up for you. You're at a full service firm, a lot of us are. To me, what's interesting about crypto, in addition to a whole bunch of other things, is it's so interdisciplinary. You really need the regulatory expertise, you need the cap markets expertise, you need litigation expertise. Obviously, you got to have the finesse dealing with enforcement and various agencies. Is that different? Do you find that's different for this particular area? Or again, do you think you sort of operated in that realm in other cutting edge areas of technology?
I mean, our law firm, we tend to staff things interdisciplinary, but in our crypto matters, we are heavily reliant on our partners and colleagues in our broker-dealer and investment management, people that understand exchanges, and our capital markets lawyers. So it does really cross-pollinate.
Okay, Nicole, you get the last word because I'm going to give a little bit of time to get everybody in and out before Chair Gensler comes. Tell us about how you got involved in crypto and how you built up your expertise.
Sure. So my formal education really focused on derivative markets, and that's where I did the bulk of my academic research. And then when I came over to do litigation consulting, I really focused again on derivatives and then foreign exchange markets. And so that I first got into crypto because it trades a whole lot like foreign exchange, traditional. And that's really how it started. Similar exchanges, similar structures, similar products, order types, you name it. And so from there, it really gave me a jumping off point because I really already understood the trading mechanisms. And then I collaborated with some of my colleagues who were more on the consumer finance side.
Excellent. All right. So Bruce, not bad, right? 5 minutes early? Okay. Thank you very much.